Okay, guys. I was intending to do a live broadcast on the Feral Farm page, and somebody told me that I was on my personal page, so I have switched over from my personal page to the Feral Farm page, which I think I'm on. I can't tell; they're so closely connected. So what I was saying before, so I'm just kind of going to go back and do what I did. So my name is Attorney Joy Farrell. I'm the managing attorney here at the Farrell Law Firm, where we focus on family law and personal injury. Over the past 2 weeks, I've done great. I'm on the right page. Over the past 2 weeks, I've done 2 live Facebook broadcasts pertaining to custody. And we talked a lot about the different types of custody, what the court looks at in determining custody. And over the past 2 weeks, we've gotten a lot of phone calls, a lot of questions in my inbox about follow-ups or just needing additional information about people's situation. So today I wanted to go live and do a live question and answer session. One, because I'm going to be going out of town today to the family law conferences down in Florida, so I won't be able to do a live broadcast come this Friday. And the other reason is so many people had questions. I want you guys, if you have additional questions, to make sure I'm answering those questions for you, because I'm sure a lot of you have the same concerns. Before I get started, disclaimer, the information I give today is for general purposes only. Every case, every person is different and unique and does require a set personal advice to your situation. So if you need very detailed advice, you need to schedule an appointment either with my office or with another attorney to receive actual legal advice. So this is just general information. It takes a lot to give legal advice. We have to look totally into your situation. I am going to go through some questions I received on my email, but this is the time for you guys to ask your questions now. So I'm going to ask questions now. So go ahead and type your questions, and I'm going to be going down and clicking on them, and I'm going to read them, and I'm going to answer them right here live, okay? So this is one from Ken. What's your philosophy or approach to a case you represent? Well, giving away my secrets here live. Here at the Farrell Firm, we believe that we're second to none when it comes to other firms in Atlanta, Southeast, Georgia, etc. Because here at the Farrell Firm, excellence is our standard. That's our motto. So we do everything above average. And so when we go into a case regardless of the case, whether it's custody, child support, divorce, personal injury, whatever, our standard is to be the most knowledgeable in the courtroom. So we know the most recent case law, not old case laws like some of these antiquated lawyers are in the courtroom quoting. We're talking about 2015, 2016, 2017 cases that just come off the Court of Appeals of the Supreme Court. So we're fully knowledgeable. And then the other approach we take is that we're fully strategic. So we're a very strategic firm. And from the onset, we treat each case as if it's going fully into litigation, even if the case may settle. Okay. So that was a question I got. So one question I received in my email a couple of times is, what happens once I sign the birth certificate? Does that give me rights? So I'm just going to, the signing birth certificate give rights. So no, signing the birth certificate does not give rights. I discussed week 1, I believe, in our legitimation section. Dads, if you're having a kid with a woman that you're not married to, signing the birth certificate doesn't do anything other than acknowledge the paternity of that child. It doesn't give you any legal rights. You may sign an administrative legitimation in the hospital if they offer that to you, but that's still not going to lay out your custody and visitation. You're going to have to go through the court system to pursue what your custody is going to be. And we're talking about legal and physical custody. We talked about that week 1. Do you want joint legal custody or sole legal custody and physical? Who do you want the child to live with? So you have to file that action and pursue it through the courts. What type of custody and visitation schedule should I expect of my child as an infant? This is a really good question, and a question that comes up a lot when we deal with small babies. Sometimes parents don't believe that the other parent can take care of a baby. But just like when I had my baby, my first child, my husband had to learn how to be a parent just like I did. And so we believe in the court system that both parents have the ability to parent. So just because you have a small baby doesn't mean that the other parent isn't able to take care of that child. In some situations where the parent is breastfeeding, we may have to make some kind of circumstances, special circumstances in those cases. You have to pump milk or supplement with formula when the child is with the other parent. We work a lot with child psychologists when it comes to custody and stuff, and it is very important for young children to actually be exposed to both parents. That's a bonding time. And the earlier you do it, the better. If you wait till the child is 3 or 4, there's going to be all kind of separation anxiety. So if you have a baby, you can expect a pretty regular visitation schedule. I mean, it may start a couple of hours, like no overnights at first, and then it's going to go into overnight and weekends, or if you're going for joint physical custody, some type of 50-50 setup. Okay, so this is from, I'm not even going to mispronounce your name, Adazi, I'm sorry. What are the requirements to sue someone for defamation of character? For instance, if the person you are divorcing has strangers write a 5+ page letter to the judge claiming that you are an unfit parent, or if they have told others that you stole money from them when it was actually them that did it. Also, is there a statute of limitation? Okay, so your concern here is in the wrong direction. I wouldn't even think about suing these people right now until I handle the divorce and custody portion. You need to be focused on that. You need to be focused on how you can bring in evidence to show that you're not an unfit parent. And quite frankly, I don't care if you stole money, because that has nothing to do with your parenting, but you need to focus on the actual custody case that's before the court right now. The judge probably hasn't even read that 5-page letter. I assure you of that, because judges aren't doing that. You know, if somebody wants to submit a statement to the court, they can do it by affidavit, but there's limitations on how many affidavits can be submitted. And so that letter probably hasn't even been read. It probably never will be read, but you need to be fully prepared for when that case goes to trial, that you're prepared to defend yourself against what your husband may be saying about your ability to parent. Defamation of character, you can go down and file that in the state court, but that wouldn't be my focus right now. Cicely, what's the ballpark for a custody case? I'm assuming you're talking about money, Cicely. Most custody cases in our office start at $2,500, depending on how hot it can get. It can be end at $2,500, but it can go to $20,000. It depends on how much of a fight we got to put up to win the case. Alycia, what age are children allowed to elect to live with a parent after divorce? At 14, in the state of Georgia, children can do an election. The election is not the end-all, be-all, although it does weigh heavily. The court can consider it. But at the end of the day, in every custody action, regardless of the age of the children, the court is going to be strictly looking to the best interest of the child standard, what is best for that child. And so sometimes what happens when we have 14 and 15-year-olds doing elections, the 14 and 15-year-old may have been living with, let's say, mom for all those years, and now wants to live with dad. And so we got to say, well, why is that? You know, is dad more lax? Is dad cooler? Does dad let me do what I want to do, and that's why you want to live with dad? Or is dad truly the better parent? Is the child having some type of disciplinary issues that the mom is not equipped to handle? You know, those are the things we want to look at when there's an election. So just because a child says they want to live somewhere, 14-year-olds, I mean, the court will consider it, but there's definitely arguments to be made as to why that should not happen. And we've defeated affidavits of elections many times over. So don't be totally confident in that just because the child has decided that you'll win on that position. Who is responsible for paying daycare for the children if it was never added to the final order, and can the father pick up the child without the mother's position? So if there's a if there's a child support order in place, the custodial parent is expected to pay all the expenses of the child. The non-custodial parent is simply required to pay child support, nothing more, nothing less. Now, if the child support worksheet put in the worksheet that the dad pays half the daycare, mom pays half the daycare, then absolutely they're to continue paying at 50-50. But if there was no mention of the daycare in the final child support order, the custodial parent is expected to pay the daycare in full. So you want to make sure if you're going through a child support case that you have representation so that you can get everything properly calculated so that you don't have to worry about it later. As far as the children, the father picking up the children without the mother's permission, if the father has visitation, he can only pick the kids up during that visitation time. Ginger, what is the process of legal separation, and can the mom get support from the father for children if she physically has the children without going to court. So, Ginger, good question. Legal separation is almost exactly like a divorce. I call them twin sisters, except when you get to the end of a divorce action, you're legally divorced. You get to the end of a legal separation, you get all the benefits of a divorce, but you're still legally married, so you can still enjoy the benefits of being married, such as staying on each other's health insurance. You can file joint taxes, and of course, if one spouse dies, you would be the beneficiary from there. So the process is to basically file the action just like you would from a divorce. If there are children, yes, you can get child support. You don't even have to file for legal separation to get child support. If you and your husband are already separated and you have the kids, you can go down and file for child support even though you're married. So you definitely want to consider if you're filing the separation for the purpose of child support, or if you're filing separation for the purpose of not being with your husband. If you want child support, you don't have to separate. All you got to do is tell the court that you guys are not living together and you have the children and you need financial support, and go through it that way, and you'll get a child support order. Okay. Okay, so I'm going to go to another question I received in my email. I'm at a standstill in my custody and divorce case due to not having an address. What can I do? I'm going to type this briefly. I'm just going to say for wife. What do I do? So you have to be able to serve a party in a divorce case or a custody case. And so anytime we don't know where someone is, we definitely use social media, friends, family, to try to locate that person. We can bring in a private process server, private investigators, or whatever to try to find the person. But you have to find them in any case, you know, dealing with like child support. Some cases you can run by publication. If you can't find them, you run in a newspaper. Service will be proper. But what's the point of running a publication on a custody case? You get in custody, but the person never knows that you have custody, so it'll be almost impossible to enforce if you don't know where they are. So you really should make a good faith effort to try to find people. Alycia says, what happened if the child refuses to visit the other parent? We get this a lot, especially in younger children who may not know the other parent that well. But these are young children, and you have to be the mother and or father and tell them, hey, you got to have a relationship here. You got to go and do it. Like I said last week during the live broadcast, you know, at one point my daughter said she refused to eat green beans. She didn't want to eat green beans. She didn't like green beans, but green beans are good for you. So you got to keep pushing it until they do it. Now she loves green beans. So the same thing, I would take the same analogy with having a relationship with the other parent. Having a relationship with your dad or your mom is good for you. You need to keep trying it till you get used to it, and just push it from there. Okay. Another question. My ex was found guilty of felony domestic violence and child abuse. He wants custody of my son. Does he have a good chance of winning? I'm just going to put child abuse in custody. Anytime we have allegations of child abuse, we're going to be really looking into that closely to see if it's true allegations or if the parent is just making it up for the purpose of the custody action. So if you have a well-documented case with child abuse, then it's not likely that parent would get custody, and probably unlikely they'll even get some type of visitation without it being supervised. The courts, again, look at the best interest of the child, and in those circumstances, is it best for a child to be with a parent who is an abuser? Ginger, again, what would be the cost of filing child support without legal separation? So, Ginger, you have the option of going through the state child support services. I don't recommend them because they're overworked, underpaid, and it'll take you forever. But that's a $25 application fee to go through that process. If you were to hire a private firm like our firm, you're going to be looking at anywhere from $2,000 and up, depending on whether or not you have your husband's financial information or not, because the financial information is very important to establishing child support. We have to use your income, his income, and the needs of the children. So we have to have all those documents in place, and depending on what we have to do, go through to get those documents will determine your price. But, you know, what I would do if I were you is schedule an appointment to come in, sit down, talk about some numbers, run some worksheets, and see how much you should be getting, and then you can make a determination as to whether or not you can survive with that child support amount. Okay. Another question I have is about grandparent custody. The grandparents have my child, not even my child's mother. What can I do? This is very common. Grandparents having the children. So I'm just going to put grandparents have children. Now, what? Let me be clear when I say this. Grandparents and third parties do not have superior rights to you as a biological parent, whether you're the mother or the father. If a third party has your child and you do not want them to have your child, then you need to take the appropriate actions to get your child. First of all, with the grandparents, if you have rights already, you can just go get your child. I'm going to be honest about that. They can't tell you that you can't have your child. They have no rights to your child whatsoever. There is a constitutional fundamental right that the parent is the best person for children to be with. There's no ifs, ands, buts about that. It's presumed that you're fit, and the third party would have to overcome that presumption to show the court that you're not a fit parent and that you should not have custody. Don't let people have your kids if you don't want to. Don't sit back. This is Tabitha. How old does your child have to be to decide where he or she wants to live? The child has to be 14 years old to make that determination. And again, the court, just because they say it is not an end-all be-all, the court's still going to look at what's in the best interest of this child. Is it best for the child to live with you, or is it best for the child to live with dad, and why? Is it because of other reasons, because the child has more freedom or more flexibility, the other parent is cooler, or is the other parent too strict? It's not an end-all be-all just because they choose to do that. Let me go back to Tabitha real quick. So it changed from 13. It was never 13 in Georgia, Tabitha. What if the mother or father is not working? Can the court force them to work for child support purposes? The court can't force you to work, but what the court is not going to do is put 0 in as your income on the child support worksheet. Every adult, well, I'm not going to say adult because some people have kids and they're not adults. Every parent is expected to be able to take care of their child. And so if you don't have a job, the courts are going to put you in at a minimum of minimum wage, which is $1,261.50 per month at a minimum. So if you're not making minimum wage, that's what you'll be calculated at. If you could be making more money, the court has the authority to impute your income into what it thinks you should be making. It has the authority to impute your income at what you used to make. So if you used to make $50,000 and you quit your job or you're unemployed, your child support probably going in at $50,000 a year. Ashley, how does visitation go for a father who has only seen the child 4 times? However, the baby is 7 months. He has a drug, gun, criminal record, is on probation. Ashley, the father, if he doesn't have any rights, then there's nothing to it. He doesn't have any rights, so we have to pursue the court to get those rights. In a case like this, let's say he did file for his rights and he doesn't know the child, we do what we call a step plan, which is a gradual plan of him getting to know your daughter. I'm assuming that's your daughter in your picture. She's extremely cute. So we would maybe let him see her for 1 hour, 2 weekends a month, and then we'll slowly increase it to 2 hours, 4 hours, and then for a full day, so that your daughter gets to know him. Him having a drug and gun record isn't going to really play a large part into custody unless there's been some type of crime against children. Christopher says, I've been going through legitimation custody process since December, but in the meantime, being kept away from the kids. Can anything be done in the meantime while I wait for a court date? Absolutely, Christopher. You should ask your lawyer, if you have one, to go ahead and try to get a temporary hearing. So sometimes these cases, depending on what county you're in, they can drag on for over a year and a half if you let them fall by the wayside. But if you're aggressive and keep pushing and tell the court you need temporary relief, you ask for a temporary hearing so you can temporarily get some visitation during the meantime. And legitimation shouldn't take that long, quite frankly. So you need to talk to your lawyer about speeding that up. What factors does a court consider when determining child custody? A whole bunch. We actually talked about that in great detail last week. Considers the relationship the child has with both parents, the ability of the parents to take care of the child and the child's needs, the bond that the child has with siblings or step siblings. The court does not consider your financial, who's more financial well off than the other parent. Socioeconomic status is irrelevant when it comes to custody. Going to consider your home environment, so many things the court can consider. The court has a lot of discretion in this area. So if you have weak areas, I'll definitely get you an attorney to argue for the strong areas, because the other attorney is going to be arguing about your weak areas and why you shouldn't be able to have custody. Ken says, are you able to drop a custody case? So I'm assuming, Ken, that you are saying that there's a pending custody case and you don't want to pursue it anymore. Yes, you can voluntarily dismiss any case under our civil procedure code. And once you dismiss it, so long as there's not a counterclaim in place, that's the end all be all. You just file it and that's done. It's closed. Okay. So it looks like I don't have that many more questions. So if you have a question, type fast, because I'm getting ready to wrap this up. Yes, pending, Ken. So there's a custody case pending. Ken, are you the one pursuing custody or is somebody pursuing custody against you? Can you give me a little bit of clarification? While I move to the next question, I'll come back to you. Carmelita, what advice can you give as far as filing for custody before divorce is filed? He resides in Texas and I'm in Atlanta. With custody, it's different from child support. Like I said, you can file the child support and still be married, but for custody, if you're married, you guys have equal custody, hands down. The question is going to be, how long has he been in Texas? Does Georgia still have jurisdiction of this case? Where are the kids? And that's going to be very important for determining that. But until you file for divorce, custody will not be determined. If in a same-sex marriage and I have a child with a man, does my wife have any rights to that child? I have a child. Oh, okay, I see what you're saying. No, your wife would not in a same-sex scenario. The man actually would. The father of that child could pursue rights to that child. However, what you and your wife will want to do is file for a a two-parent adoption and subsequently move to adopt that child, assuming that the father would go ahead and terminate his rights. Okay, and Ken says that was for someone else, for a friend, not me. All right, tell your friend to call us, Ken, because there's some more to that. But it's very easy to dismiss if he doesn't want to pursue it. But if he doesn't have rights to begin with, no matter what you're being persuaded with, don't dismiss. A lot of times, well, I'll take care of child support if you don't pursue custody. Pursue your custody rights, because there is a time period where you can waive those custody rights. And if you wait too long to file that case, you won't be able to file it later on. So he should definitely seek counsel about that and find out if that's the thing to do. Carmelita's coming back and saying he's been in Texas since February. This is May. So he's been there 3 months. Girl, you got 3 months to file a divorce to keep it in Georgia. You can file within 6 months of him moving from the state, but if you wait 6 months and 1 day, you will not be able to file in Georgia, so you need to move quickly. Okay, and that looks like all the questions I have. I'll wait a few more minutes to see if any of you guys have any last minute questions you want me to answer. I'll probably be going live again next week. Okay, some more questions just popped up. Ryan says, my son has special needs and gets a Social Security check every month. With shared custody, is the amount of his Social Security check split in half? Split in half between who, Ryan? What's your question specifically? Because he should actually, the child should receive the benefits of the check. So when we do child support and there's a child Social Security check, so let's say, for instance, your child support obligation would be $1,000 and his Social Security check is $500, you would get the $500 credit from that Social Security check if it's coming from you, and then you would technically only owe $500 in child support. So, it kind of depends. But no, like, you and mom don't split the check. It's technically supposed to be for the kid, but I guess if you guys are sharing custody, you could split it between the two of you to care for him. Is there a child support order on this case? There's a lot of questions I have to answer, Ryan. You may have to come in. My kid's father and his wife called Child Protective Services and told a lot of lies, and they came out and searched my house and checked my kids. They didn't see anything wrong. They dropped the case, but because of lies they told, should I bring this up in court? In the paper they said there were no problems at all. Absolutely. People do that all the time. Actually, anytime there's a custody action, divorce, we can almost 60% of the time expect somebody to call CPS to come out to try to strengthen their case. But it only strengthens yours to say, look, they're harassing me. They came out, they checked my environment, everything checked out. I don't have any problems over here. You can definitely bring that up in court. Sonia, what would happen to a father who lied about taking a parenting class twice and on all his paperwork that was notarized by his mother that he presented to the court and the judge did nothing? So the parenting classes are required in most counties to anytime there's a custody case. And Sonia, what happens when you go to the parenting class, and you probably know this because I'm assuming that you went, the parenting class gives you a certificate. So there's no document that needs to be signed and notarized by his mama. The class gives a certificate, and the class instructor files that certificate with the court, and that's how it's determined that the class has been taken. If he has not taken the class and the order is already issued, he's required to take the class. You may want to file a contempt if it's worth it to you to do it, but the parenting class actually are really helpful to helping people co-parent. So I can see why you want him to do that. And depending on who your judge is and your county, sometimes you got to force these judges to lay down the law, and that's why you might want to get an attorney depending on what the situation is. I'm with a guy whose baby mother is homeless, living in hotels. How can he serve her if she has a TPO and he doesn't have a resident for her in Georgia? So, Cicely, we're going to have to find out what hotel she's in and send a private process server out there to get her, pretty much. And once he doesn't serve her, so it doesn't matter if she has a TPO. He's not making contact with her, and the TPO could only prohibit his contact with her, not him and the child. But even if the TPO says he can't see the child, if he files for a custody action, the Superior Court judge can still give him access to the child if he finds that it's not harmful for the child to have visitation with him. So he's going to have to be pretty aggressive, try to find out how she's hotel hopping, and as soon as he knows where she is, have her served. If he knows where she goes to the grocery store or where she likes to hang out, have her served there. He's going to have to know where she is to serve her. Is it better to file for divorce in Atlanta than Texas? How's a lot different? I'm not licensed in Texas, so I can't really give you my thorough opinion on that. But I'll tell you, I've had some cases come over from Texas where I've had to incorporate them here in Georgia. In Texas, you don't want to do it in Texas. You want to do it here because you do it in Texas. Texas says, I know in one of my cases, like you can't leave Texas unless you have permission with the child. You don't live in Texas, so you don't want Texas saying nothing about what you need to do. You live in Georgia, so you need to file in Georgia and do it before your 3 months run out. Okay. I think I've hit all of your questions. I give you a few more minutes for those who may be typing. But like I was saying a few minutes ago, I'll probably go live next week and discuss custody again or child support or whatever. If you have a particular case that you need guidance on, I can give you questions all day, but you're going to need a legal expert. So you may want to come in or make an appointment. I'm going to put our phone number on the screen. You can call us if you want to make an appointment. You can call the office and we'll get you in, or you can go online to our website at feralfarm.com. You can actually book an appointment directly from our website to come in. Our consultations are $150. It gives you an hour with one of the attorneys here in the office, and you can bring all the questions you have, and we'll talk specifically about your case. All right. So thank you guys for tuning in today. I hope I answered all your questions. Be on the lookout for any other pop-up question and answer sessions. If you like our page and follow our page, you'll get the notifications to do that. So you guys have a great rest of your week.